It's California Edition. I'm Brad Pomerance. We are joined today by Sniff. He is the sheriff for Riverside County. And sir, as you know, back in February, a court ruled that California law, which required some type of showing cause when you wanted a CCW carry concealed weapons permit, that was unconstitutional. The court was very clear that they thought that the restrictions were too much. What do you make of that decision?
Well, it was an interesting case decision. It was based on some other legal changes that California made banning open carry a couple years earlier. And if you recall, the original court case that came out of San Diego County was the sheriff denied a permit and didn't care for the cause that somebody offered. And that case was given a summary judgment by the federal courts. It was appealed up to the circuit court, Ninth Circuit. And between the original court case and the appeal that went up to the Ninth Circuit, California changed and banned open carry. So for all intents and purposes, for the last few years, legally you couldn't carry a gun outside your front door. And that's really what that court case hinged on. So CCW issue, carrying a weapon out in a public place are two different issues, but they're related.
So open carry, did the court decide on that as well?
No, the legislature did. It reacted, if you remember, a few years ago when we had open carry lawfully in California for many, many years, all the way back from the late 60s, as I believe. And what happened was some people pressed the edge on that, on the principle of the Second Amendment. You remember the weapons at Starbucks, people with AK-47s on street corners. And so there was a public reaction against it. That also originated, ironically, out of San Diego County.
So because the open carry ban is on the books, and still is, the court ruled that the severe restrictions on CCWs effectively eviscerated the Second Amendment, so they loosened the restrictions on CCWs.
Well, they had no choice because the Second Amendment did play a role in there. What remains to be seen, and that court case out of February that you mentioned is currently under appeal by the Attorney General.
Yes, Kamala Harris has appealed the ruling.
It has been stayed by that same court, so it's not binding on any law enforcement. Law enforcement is largely not changing. They're waiting to see what the outcome, because I think almost everybody, at least from the legal counsel we've had, is kind of a wait and see. We don't quite know, because the legislature could still pass additional laws changing. They could certainly rescind the ban on open carry that they created a couple years ago. At the time when they banned open carry a couple years ago, many of us told people in the legislature, you are causing a problem with the CCWs. Open carry allowed you to carry a gun unloaded but openly displayed. A carry concealed weapon allows people to be licensed to carry a hidden, loaded firearm into public places, markets, theaters, and on the road. So it'll be interesting to see how California, which is very much anti-gun, reacts to end up having a lot of CCWs issued willy-nilly.
What do you think of open carry? Before we get to CCWs, I want to explore that. It is, it's a little, for someone who lives in a large city, it can be a little unsettling if you just see someone with, a rifle on their shoulder.
Right. For many years, though, and being a long time in law enforcement, it was not really an issue, because any peace officer in California for the last 30, 40 years could go up and we could ask, is that gun loaded? And we could take whatever precautions we need safety-wise, and we could check to make sure that it was an unloaded, openly displayed firearm.
But here's what's odd. I mean, you can put it on your shoulder and it's unloaded, but you have it below your jacket and it's loaded.
Yes.
What's the difference?
Well, I think the things that we can see are less of a concern than the things we cannot see, at least from a law enforcement perspective. And so having guns, loaded firearms, not unloaded, but loaded firearms underneath the car seat, in the glove box, or carried on somebody's person into a public place, things that you can't see often frighten law enforcement officers more than those they could see.
When we did have open carry, could you have bullets in your pocket?
Yes, you could have bullets in your pocket, and in fact you could have bullets or cartridge mechanisms like a magazine or a speed loader on your belt. They could not end up being in the weapon. So they were close by. And really, for the Second Amendment purists, that often met the criteria because, as you know, you could actually load that out of your pocket pretty quickly.
Very quickly.
And so the self-defense issues that are wrapped around this case, the Peruta decision, That's what that all revolves.
That's the CCW case.
That's the CCW case at the Ninth Circuit.
So what are you doing in the wake of the February decision, the Peruta decision? Are you starting to issue CCWs in a more permissive way? I know you said there's a stay, so we're not clear, but where are you going?
Well, each county and each city,
Right.
every police chief in the state and each of the 58 sheriffs can issue carry concealed weapons permits for their jurisdiction. Riverside County, which is largely still a very rural area, we operate quite a bit differently than the big urban areas like Los Angeles and San Francisco, or San Diego for that matter. But we've actually liberalized that policy quite some time ago. So we will not issue to every single person, but for most law-abiding citizens in Riverside County, you can get a CCW. We do require them to articulate what the good cause is.
But arguably, you shouldn't be requiring that.
Well,
if this decision sticks.
If it stays. And our department, just like every other law enforcement agency, will comply with the court cases. They'll comply with the law.
So what tends to be cause?
Well, there's a variety of reasons. Anything that puts you over a risk of an average citizen in California. And in our case, we have probably 1,000, 1,100, a little over 1,100 permits out across Riverside County. And I'll tell you this, that no two of the good causes are the same.
Right.
So there are really a variety of reasons on it. Almost all of them eventually come down to self-defense or self-protection, but we simply don't accept just those words alone. We actually ask citizens to spell it out a little bit.
So if I came to you and said I'd like a CCW permit because I want to be able to defend myself in case I come up against a bad guy,
right.
Is that enough?
Sure, and what you end up, you articulate a little bit better, but what that process involves is you have to be a resident of Riverside County, of that jurisdiction. It takes about 60 to 90 days. There is some training that's required. There is a background process, not only with the state, but here locally, so we know who you are, licensed accordingly on that. But most people can apply, and in our case, a very high percentage of those people that apply meet that criteria.
Speaking of training, we've discussed that I may join you on a future episode of California Edition at a training facility, which I think will be quite enlightening. The reason why we discussed this is because you indicated that you've seen a spike in CCW applications amongst women.
Yes, we've seen a spike across the board, but especially significant among women. And an interest in firearms by women a lot. And some of it's self-defense. Some of it is probably driven by the media.
Sure.
And some of it is driven by the recent court case. But there's been a lot of interest in how you go through the process to get licensed to carry a concealed weapon. And again, it's not necessarily for those that just want to carry it on their person.
Right.
Because many people get a license and only carry it when they need to carry it in an area where they're going to be at risk. And the reality is you don't need a CCW to buy a weapon. That is a Second Amendment right in California, even though California has a very restrictive policy on what guns are available. But you can buy and carry in your home or place of business a concealed weapon and a loaded weapon, and is not in violation of the law.
In your home.
The CCW only takes care of licensing those people that go outside their front door, out in our public ways, markets, out driving on the street, theaters, sporting events.
If you have a CCW, do you need to have it on your person?
No, it can actually be in your glove box or underneath your car seat. So it can be physically on your person, underneath your car seat, in your glove box.
It needs to be accessible.
It needs to be accessible, but the idea is it covers you for carrying it concealed from view.
At the same time, we have heard statistics which indicate that if a gun is present in the home, there's an increased risk of its usage in a violent way.
Well, and as I've often underscored to you in other interviews, the reality is if you own a firearm, regardless of carrying a concealed weapon permit or not, just a home firearm or business firearm, you owe it to yourself to understand there's a lot of responsibility with that and go through the appropriate training. And untrained people do end up. But you also see a huge argument out there across the United States at this point that those areas where they have carried concealed weapons pretty liberally and they do have firearms present, they have a reduction in crime.
It's a really complicated, fascinating issue, and I am so glad you were here to enlighten us about what's happening on this issue that will continue to be discussed for years and decades to come. He is Stan Sniff. He is the Riverside County Police Sheriff. I'm Brad Pomerance. It's California Edition.